much, Your Honor. Your Honor, I should like, with your permission, to share 10 minutes of my time with Mr. Timothy Jonas. Yes. I will therefore take your leave to speak for 10 minutes, for 20 minutes, if you can tolerate me for that long. Your Honors, notwithstanding, Your Honor, the President's identification of the main or one of the main issues in this case, which relates to the issue of jurisdiction. There's no gainsaying the fact that this case is about the elections in Guyana, which were held on the 2nd of March, and for which 4 months later, Guyanese are still awaiting results. The motion filed by Eslin David relates to the counting of the votes and the definition of the words final and credible in the order of recount. And the decision of the Court of Appeal by Justices Reynolds and Gregory identified the meaning of more votes cast in 177(2)(b to mean more valid votes cast, and both of them factored in that definition as an interpretation of Order 60. Now, Order 60 could only have meant that they were defining what final and credible meant. So what we are dealing with, I presume in elections practice, the voting, the actual voting is the heart of the election. But certainly the counting of the votes would be the limbs of the election. Your Honors, the immediate issue in this case, issues in this case, are the right of appeal from the decision of the Court of Appeal, the interpretation of the word votes in Article 177(2)(b, and the jurisdiction of this court to make that interpretation. I respectfully rely on the submissions we have made in this court on these matters, and I rely also on the submissions of my friends where they coincide with our interests. However, I would like to mention one aspect of our submissions before I move on to other matters, and that is the case, the Guyana case. Your Honor, the Guyana case dealt with an interpretation of Article 177(4). And there is no doubt upon reading the decisions in that case of Justice Japan and Justice R.H. Laku that they said quite clearly that election of a president meant that the elections must be concluded. And they meant that the interpretation of the Constitution was limited to the issue of the qualification of the president. There's no doubt about that. And we rely very strongly on that case. The decision of Justice George in that case concerned the question of the oath. What is an oath? Your Honor, we, as I said, we support the submissions of my friends where they coincide with our own.
Mr. Ramkran, you have to tell me who are your friends.
Mr. Mendez, Your Honor.
Yes.
The submissions of the appellants in this matter.
I see.
Your Honor, the ruling of the Court of Appeal that votes mean valid votes is on the surface an innocuous finding because votes can mean nothing else. And His Honor Justice Witt alerted us to that. And in fact, valid votes and invalid votes are recognized and somewhat defined in the Representation of the People Act. For example, Section 87(2) provides that in counting the votes, the returning officer under this section is required to reject as invalid and not count votes with no official mark, are not marked for a list of candidates, or are void for uncertainty, or are marked for more than one list, or identify the voter. So those are clearly invalid votes, and those votes that do not have these characteristics, these invalid characteristics, would obviously be valid votes. And the word valid is repeated in several sections of the Representation of the People Act. For example, Section 87(1)(f)(1) refers to valid votes cast for each list of candidates. It requires the returning officer to deliver to the chief election officer valid votes cast for each list of candidates. And Section 96 also refers to valid votes. So we are not, under normal circumstances, we would assume that valid means the things that the Representation of People Act talk about, because valid and invalid votes are referred to nowhere else. They are not referred to in the Constitution. And one is tempted to assume that when the Court of Appeal ruled that more votes meant more valid votes, that is what they were talking about. We're not sure, and I'll get there in a little while. Your Honor, if that was what was meant by the Court of Appeal when they made that ruling, whether they had jurisdiction to do so or not, this would not have been necessary. This appeal would not have been necessary because it would have been an interpretation that we could all agree with. But that was not how this.
Mr. Ram,
Yes,
Mr.
sir.
Yes. Question. It seems to me, reading the legislation, that a valid vote in the context of the election of members of the National Assembly must be the same valid vote as the vote for a president, because they are deemed, or certain persons on the list are deemed to be a presidential candidate. As soon as you have an interpretation which gives a different meaning to valid votes, then you get a very difficult situation. As I said, the elections are, it seems to me, like a Siamese twin. They're different, but as it comes to counting of votes, they must have the same system, and that system can be found in the Representation of the People Act, it seems to me, but maybe you can comment on that.
Well, Your Honor, if valid means something else, then it means that the president has to be elected on a different quality of vote, and not the quality of vote that is found, the quality of vote that is provided for in the Representation of the People Act. But what quality of vote can that be? According to the assertion of Ms. David, the quality of the vote has to be in accordance with the order of recount, which in two places, in the order of recount itself and in the addendum to the order of recount, it refers to final and credible and final credible vote. Your Honor, but the order of recount is subsidiary legislation. And in our interpretation and General Clauses Act, at section 21, subsection B, it provides that no subsidiary legislation shall be inconsistent with the provisions of any act. So final and credible cannot be interpreted to mean anything else than valid. Final and credible cannot add an additional layer of credibility on the meaning of valid that Ms. David seeks that we apply. So that at the end of the day, regardless of the setting aside the issue of jurisdiction, at the end of the day, the interpretation of the Court of Appeal of more votes, sorry, meaning more valid votes, can only mean the valid votes in terms of the Representation of the People Act. So, Your Honors, when the Chief Election Officer seizes this window of interpretation and uses it as a window of opportunity in his letter of 23rd of June, relying on the decision, his letter of the 23rd of June to the Commission, relying on the decision in the case of Eslyn David, he said he's taking note of the guidance of the Court of Appeal in Eslyn David against Chief Election Officer in the preparation of my report under Section 96 of the Representation of the People Act. We don't know what he's relying on. He's certainly not relying on the interpretation of valid as we know it, as has to be construed in the recount order and has to be construed in the Court of Appeal's decision. So the Chief Elections Officer's letter, written one day after the decision of the Court of Appeal, when that decision had been stayed, in my respectful submission, this court ought to have no hesitation in ruling that that letter should be set aside and ruled null and void. In addition to doing so with the decision of the Court of Appeal, Your Honor, the letter of June the 23rd by Mr. Lowenfield, the Chief Election Officer, was in response to a letter by the chairperson of the Commission, Justice Claudette Singh, dated the 16th of June, in which he requested him to give a report on the results of the elections in accordance with the recount results, the results of the recount. Your Honors, the material before you contains all the report, the recount results, the report of the CARICOM mission on those results, and all that is required. A statement had been issued by the Commission on the same 16th of June, indicating that the Chief Election Officer would be asked to provide a report to ascertain the results of the elections under Section 96. That letter was duly written. Your Honor, Section 96 of the Representation of the People Act provides no opportunity for the Chief Election Officer to make a judgment on the results of the elections. He's required under Section 96. He shall, after calculating the total number of votes, of valid votes, of electors which have been cast for each list of candidates, on the basis of the votes counted and the information furnished by returning officers under Section 8411, ascertain the result of the election in accordance with Section 97 and 98. The recount order preserves the function of the chief election officer under Section 96. And the chairman of the Elections Commission wrote to him on June the 13th, asking him to provide the results of the elections on the basis of the recount results and under Section 96. The chief election officer, whether he ignored the letter or not, he certainly interpreted it in a matter of his own imagination. The imagination based on the case on this case, lopping off 115,000 votes and reversing the results of the elections to give APNO AFC the win instead of the PPPC, which had been declared as obtaining 15,000 votes more than APNO AFC in the recount results. Your Honors, I would respectfully seek your intervention in going a step further and not only ruling, not only setting aside the Court of Appeals decision, and ruling the direct consequence of that decision, namely the letter of the Chief Election Officer of June the 23rd to be null and void. I respectfully seek Your Honor's intervention to say what are the valid results of these elections. This case is about the elections, and this case is about the counting of the votes. And Section 96 and everything else points to the recount results being the valid results of this case. There is disputation about what the valid results are. And unless this court takes a position on what the valid results of the elections are, if this court seeks to kick the election can down the road and not to go down that road itself, we will be here very shortly. Not saying I will be here, but the issue will be here very shortly for this court to once again pronounce on the elections in Guyana. Your Honors, the affidavits and the material before Your Honors clearly demonstrate that this is a matter of great disputation in the country at the moment. Not asking Your Honors to seek any information outside of the parameters of this case. This case has all the evidence before Your Honors as to the disputation. I'm merely asking Your Honors to take this material before you and pronounce on the elections results and bring this matter to a close once and for all. It is 4 months now, and the people of Guyana need relief from this torment. Your Honors, I am very close to the end of my 20 minutes. And unless there are any questions that Your Honor has, I would like to hand over to my colleague, Mr. Jonas.
I do have another question. I'm reading this letter from the Chief Election Officer, and he's saying that he is what he is sending is a report in accordance with Section 96 of the Representation of the People Act. That's what he's saying. And he says that he has taken note of the guidance of the Court of Appeal. Now, there can be two situations. Either he interpreted that decision rightly, correctly, and just doing what the court said, or he interpreted that decision wrongly. That makes it a different kind of issue then. But if it is the right interpretation of the decision of the Court of Appeal, that would mean that by changing one word in 177.2, they would have changed the whole system of the Representation of the People Act, because that act has very clear a very clear system of counting votes. And when it comes to counting votes, there is no difference, I think, between presidents or between members of the National Assembly. Then it's counting the votes on the list, and the one with the most votes on his list and who is the presidential candidate becomes president. So the question is now: is this the interpretation that he took? Is that the interpretation of the decision of the Court of Appeal, or is this his own fantasy?
Your Honor, I wouldn't venture an interpretation of the decision of the Court of Appeal because it is not clear what the court is saying. The court is saying that we interpret more votes to mean more valid votes in accordance with Order 60 of 2020. That's the recount order. Yeah. And the recount order says final and credible result. Now, we don't know what the Court of Appeal, what interpretation the Court of Appeal put on final and credible. Mr. Lowenfield feels clearly from the fact of his letter of June the 23rd that he believes the Court of Appeal has given him leave and license to determine of his own accord whether a vote is what the terms of valid mean, whether he can, we don't know, he hasn't said, but he certainly used what he understood the Court of Appeal to mean, to take away 115,000 votes.
Okay, now, the Chief Election Officer is part of this case, but he chose not to show up. But I suppose he has not been sued in any way about this in any other court. Is that true?
Not to my knowledge, Your Honor. There are some private criminal charges which have been brought against him yesterday or the day before in relation to misfeasance in public office. But that's all. I read that in the newspapers. That's all.
Okay, well, we can't believe everything, but anyway, maybe somebody knows if there is a case about this particular issue against the Chief Election Officer. No civil case in the High Court has been brought against the Chief Election Officer in relation to this. That's good to know. Thank you.
Okay, thank you, Mr. Ramkaran. Mr. Jonas, you don't have a lot of time, so please go ahead.
Thank you very much, Mr. President. I'm grateful to Senior Counsel for ceding 10 minutes to me. Mr. Justice, Witt raised a point which I would like to focus on, please. He discussed the context in which this concept of valid votes is raised. I think that is important because it goes to the jurisdiction of the Court of Appeal that I would like to address. In our submissions, and if I can refer you please to page 2155 of the record, we trace a line of authority out of England, albeit, which describes what the Court of Appeal can do upon hearing an appeal from a decision of the judge below, where that judge below is sitting as a superior court of record in contradistinction to judicial review. And the culmination of that is set out at paragraph 15, where we simply very briefly cite the decision of Vice Chancellor Clark in Cheltenham. At the bottom of that page, please, 2155, that where the judge purports to make an order which he has no jurisdiction to make, that is not an order within the section at all. So we rely on that, please. And we believe that if this court finds that the Court of Appeal did not have jurisdiction, whether it acted prematurely before the actual election of a president, whether it acted in the absence of rules, those rules being mandatory, or whether on the facts before it, it made an order which was outside of the parameters of Article 177 on any of those three limbs, all three of which we contend. It acted, the order it made was not an Article 177 order, and therefore is susceptible to appeal to this court under Section 8 of the CCJ Act. I have heard disputation about sovereignty and agreements and that kind of thing. I would simply point out in response to that, that unlike the United States, where a treaty is made law in Guyana, as in the rest of the Commonwealth, the agreement itself has no force of law. What has force of law is the CCJ Act, and the CCJ Act incorporates the agreement, and that is what gives us law. So therefore, we are in the same position, and with respect this court, in determining its jurisdiction and the jurisdiction of the court below is in the same position as the CGU and the Cheltenham case, which are cited in our authorities. Now at paragraph 26 of our submissions, we raise this point, which I would like to recommend to your honors. As long ago as Ex parte Shaw in 1952, the court pointed out what is the record. For me, this is important because, as Justice Witt pointed out, the order of the Court of Appeal is on its face innocuous. Votes means valid votes. But it is important to consider the record as a whole to see the wide-ranging effect and implications of something which on its face is innocuous. Now I'm going to beg your honors to forgive me a liberty. I had filed in the Curious platform a letter to the court asking for permission to refer to a 2015 decision of the English Court of Appeal, Patel and Musa, P-A-T-E-L v. Musa. Interestingly, when I was checking just before I sat, just before the court sat, I didn't see that it was recorded. Patel and Musa is a 2015 EWCA 434.
Just a second. EWCA what?
434, please. Yes. EWCA Civil 434.
Yes.
And in that case, the decision of the court below was equally innocuous. The court below just said the application for permission to appeal the decision of the district judge is dismissed. But as Justice Clark said, sitting in the Court of Appeal, that the order can't be read, and I'm reading from paragraph 18, the order cannot be read in isolation, and there are many indications in the surrounding circumstances that it was meant to give effect to a decision of quite a different kind. So it's important to look at the entire record to see the implications of this innocuous order. And in that context, please, it is our respectful submission that the circumstances of that innocuous order point very clearly to the fact that what was before the Court of Appeal had nothing to do with construction of the Constitution. What was before the Court of Appeal had to do with construction of Order 60. And what happened is that by some leap of logic, the discussion of Order 60 and its examination by the Court of Appeal became conflated into an assessment of valid votes. Now, the reason I say that is that if I can refer your honors, please, to the order itself Order 60 is at page 105 of the record. The order very specifically repeats the language of the Representation of the People's Act, Part 9. And Your Honors will have read from our submissions that each part of that act should be construed separately as a unit in itself. Part 8 deals with how you identify your voters and make them produce an ID card and put their finger in the ink so that you are sure that no dead or overseas people come to vote. Part 9 of the act is mutually exclusive, it's separate. It deals with after the ballots are compiled in a box, how you count them, counting the ballots. And what Your Honors will notice, if I start at page 105 of your record, which is the order. The second whereas clause speaks to requests for recount. The third whereas clause speaks to a total recount, determining a credible count. On the next page, the second paragraph, recount process. The first paragraph, recount of all ballots. What Your Honors will see going through the last paragraph on that page, recount of ballots, is that what is contemplated here is a recount of ballots. There is no mention here of votes, valid votes, invalid votes. And that is the context that we have to consider how the Court of Appeal arrived at a discussion on what is a valid vote and what is not a valid vote. Of particular interest is the final whereas clause at the bottom of page 106, which says, we will conduct the aforementioned recount of all ballots cast, including the reconciliation of the ballots with ballots cast, destroyed, spoiled, stamped, and as necessary. Now, if we refer back to the Representation of the People's Act, Part 9, you will see that in that context is how we identify a valid vote. We are dealing with ballots, but we don't identify those ballots as a valid vote until we assure ourselves that it carries the unique 6-digit stamp, that it has not been spoiled or destroyed, that the voter clearly showed where he marked his X. After we reject those votes, those ballots which are unclear, what we are left with for the purposes of Part 9 are the votes which count toward the electoral process. Now, the question then arises, if the order itself does not pertain to valid votes, how is it that the Court of Appeal conflated this question of counting ballots with a definition in 177.2 of a valid as opposed to an invalid vote? If the Court of Appeal was not required to and should not have tried to construe Order 60 in that light, it acted without jurisdiction, in my respectful view. And in fact, both judges in the majority, giving the majority decision of that court, very specifically inform us that that is exactly what they did, and that they therefore acted without jurisdiction. If I can refer you, please, to the decision of Mr. Justice Reynolds. This is at page 3377 of your record. At paragraph 7 of his decision, and at what he says at paragraph 7 is replicated, please, by the decision of Justice Barnes. Page 3377 of your record at paragraph 7, Justice Reynolds says, having regard to the affidavit in support of motion, the affidavit in answer and submissions, the following issues are to be determined. First, does the court have jurisdiction? Second, does Order 60 of 2020 require GCOM to determine the final credible count of the elections? And with great respect to the learned Justice Reynolds, I entirely agree with him. Those were the issues for him to determine. And none of those issues had anything to do with construing the Constitution or determining what a valid vote was.
Just a minute, you said page 337?
3377, please, sir.
Oh, 3377.
3377.
Yes.
Now, if your honors agree with me that the record, the face of the record, the entire thing needs to be looked at, the motion as well as the affidavit, then the question arises, what issues come up for the consideration of the court based on the affidavit of Ms. David filed before that Court of Appeal? And if I can respectfully refer you to her affidavit, this is at page 91, please, of your record. 93. Ms. David goes through the gamut of the language of the Representation of the People's Act and the order. She makes reference to the order, and she complains that GCOM have asked Mr. Lowenfield, the CEO, after their deliberations, and those deliberations we cannot look at because under Section 140 of the Representation of the People's Act, they are inadmissible. But GCOM has, after its deliberations, instructed Lowenfield to submit his report based on the recount which was conducted and approved by CARICOM. And that is her complaint. And interestingly enough, the only paragraph that I have been able to discern in this entire application and affidavit, which speaks to a credible count, a credible vote, credibility of the March 2nd, 2020 elections, is in paragraph 27. This is what Ms. David says in paragraph 27 of her affidavit. On the 16th of June, the Elections Commission stated it did not have the legal authority to determine the credibility of the March 2nd, 2020 general and regional election, and by extension to arrive at a final credible count as required by the aforesaid orders. Now, Your Honors, when you look at the statement of the chairman at the Elections Commission, the chairman specifically does not say anything about her authority to arrive at a final credible count. She specifically says nothing whatsoever, and that record is before you. So by paragraph 27, what this applicant seeks to do is to conflate the issue as to the credibility of the election overall, which is an issue for Article 163, the High Court to decide, with the Order 60 issue of a final credible count of ballots. And that is the single tenuous thread by which the Court of Appeal, having said that it needs to construe the order, decides that it is going to give an interpretation of Article 177.2. Now, if this court agrees that all the issues that are raised in this affidavit pertain to a complaint that GCOM conducted a recount and then instructed Lowenfield to file a report using the recount numbers, then that conflation in the single paragraph 27, which led to judgments from 2 of the 3 judges in the Court of Appeal, is entirely without any contemplation of Article 177. What I've done, Your Honors, and I found that it helped me, so I'll ask you to forgive me, please, the importance of using my own tools, is I have transposed the language used in Article 177.4. On its strict language, Court of Appeal shall have exclusive jurisdiction to hear and determine any questions as to the validity of an election of a president, insofar as the question depends on the interpretation of this Constitution. I'll ignore the rest because we've agreed the rest is not relevant. In the context of this argument, please. If I transpose that language, the Court of Appeal can interpret this Constitution to deal with any question raised that requires it, because it depends on the interpretation of the Constitution. The questions which are raised by Ms. David are questions that go to dead people voting, overseas people voting, but those questions are raised as hearsay. The only meaningful question raised in the entire affidavit of Ms. David is that she's upset that GCOM has said to Mr. Lowenfield, use the recount numbers and give us your order. And if that is the real issue on the face of this affidavit, then none of that pertains to whether the court should try to construe Article 177.2. And therefore, the Court of Appeal acted entirely without jurisdiction when it made that leap of logic to try to segue from discussing ballots counted under Part 9 and under the order into the validity of an election.
Mr. Jonas, you're running out of time.
I'm very grateful to Your Honor.
Your time. Yes. Okay. Thank you very much. Mr. Kashir Khan.
May it please Your Honors. I wanted to begin by first of all expressing my grateful thanks to the court for allowing an opportunity to be heard in this matter. It is not often that in the context of such matters that the lesser mortals, so to speak, parties that I represent, often have an opportunity to provide a perspective with respect to what takes place outside of the two big boys, so to speak. I also wanted to take the opportunity to express my thanks to Mr. Mendez, as well as to Mr. Jonas and Mr. Ramkaran, for providing much of the basis for the application, which I gratefully adopt. That, of course, allows me the opportunity, with the court's indulgence, to look at some other aspects of this argument in a way that perhaps, I hope, brings clarity to what is before us. And I wanted to begin in the context of my submissions for special leave and to ask the court to take note of the case of Mohan versus Persaud, in which I believe it is in paragraph 11 of my submissions, in which the court had this to say: in deciding an application for special leave where the Court of Appeal has refused leave to appeal to this court, the court will give careful scrutiny to the Court of Appeal's reasons for doing so. The practice of the court has been that it will grant special leave if there are egregious errors of law or a substantial miscarriage of justice. That is taken almost verbatim from the formulation of De La Bastide precedent in Merchandini versus Rediffusion, and that has been more or less the benchmark which this court has adopted. In support of that particular position, I then referred to the dicta in LOP Investments versus Demerara Bank Limited, in which I'm just quoting from paragraph 21, in which it had this to say, quote, "It seems to us that regardless of the outcome of the appeal, it is of benefit both to the legal profession and the commercial sector," I would substitute that to be the entire Guyanese sector, "to have definitive answers to some of the questions raised by the applicant in this case." Your Honor, it is my respectful submission that there can be no doubt that the questions raised in this case requires definitive answers. It is also similarly my respectful submission that egregious errors of law and a substantial miscarriage of justice has occurred. And it is for those reasons, in addition to the other reasons that I have proffered, that I have asked the court to grant the application for special leave. I will not canvass too much the first part of it, because I believe that the court is well seized of the antecedents which gave rise to the court and the court overall as part of the arbiter in the context of the treaties which all member states have signed. And it is in that, under that underpinning, I would similarly ask the court to grant special leave. Now, Your Honors, I will choose to go through the issues as given to us by the court. But before I do so, by way of an introduction, I wanted to speak a little bit about Article 4.3 of the CCJ on which much reliance is placed by my friends as giving some sort of footing for the ousting, so to speak, of the court. And I will recite it because I believe that it requires some distillation. It says this: nothing in this act shall confer jurisdiction on the court, meaning the CCJ, to hear matters in relation to any decision of the Court of Appeal, which at the time of the entry into force of this act was declared to be final by any law. Your Honor, in very short terms, this is simply a savings provision, nothing more. When you look at the language, it says clearly that this court is not supposed to hear matters in relation to any decision of the Court of Appeal, which, when this law came into account, and the word is was decided to be final by any law. This, when one examines Guyana's judicial history, refers straight away to the period of 1971 to 2005, when Guyana abolished decisions from the Privy Council and the Guyana Court of Appeal became the final court for Guyana. This was intended to save that jurisprudence. This was intended to do nothing more than that. In the same Merchandini case, De La Bastille had to deal with the transitional provisions as it relates to Barbados. If it is that the court would like further amplification of that, I would refer the court to one instance which I was able to come across, where that engaged the court's attention, and it is in the area of land law. For many years, the case of Brandis and Craig, which was decided in 1980, had made a decision that effective entry into land for the purposes of prescription could be accomplished by the mere transfer of title. And that was the decision of Justice Gray. Even though some doubt had been cast in that decision by an orbital dicta of Justice Chance, he then was in Supli and Kumar, nothing was done about that decision until 2015, when this court in Ramlagan and Narayan definitively pronounced on the issue. And since then, the facts of Brandis and Craig have been confined to that particular case. In the same light, Your Honor, I'm suggesting to the court that you have to look at 4.3 as merely preserving the jurisprudence that accrued between 1971 and 2005. Section 4.3 has no ambulatory effect. Section 4.3 cannot, my respectful submission is, put this court, oust this court from having a review of a decision that took place in 2020. Any decision of the Court of Appeal, it is my respectful view, that came after Guyana adopted the Caribbean Court of Justice is open to review. There is no finality. The word was is for past tense. It was intended to preserve the jurisprudence, as I said before, from 1971 to 2005. Nothing more. As it relates to that, Your Honor, by way of amplifying the point, and I apologize in advance because I don't know if the court has had an opportunity to upload the decisions for the Court of Appeal in the matter at hand, in the David matter. These decisions were only made available, I believe, on Monday, and I wanted to refer the court, and I'm now going into the issue of jurisdiction. I wanted to begin by looking at the dissenting judgment of Justice Rishi Persaud.
Counsel?
Yes. Yeah.
I think you can take it that we have all three decisions.
I am grateful, Your Honor. Well, I would like to refer the court to paragraph 11 of Justice Rishi Persaud's decision. And Justice Persaud in dissent has this to say. He says, though it does not appear that the issue of provision making under Article 175 was raised, I find myself persuaded, if not bound, by the pronouncement of our apex court at the time as it relates to the scope and ambit of the jurisdiction conferred by Statute 177.4. Your Honor, I would ask the court to respectfully adopt that view for the reasons that I've said earlier. What we have here is the Court of Appeal in 2020 operating as a court that is now at a secondary level. And it was not within their purview, most respectfully, to depart from the decision that was made in UC Guyana in 1980, when the Court of Appeal was in fact the apex court. It is this court's function, the CCJ, that can do that. But it was not, most respectfully, open to the Guyana Court of Appeal of 2020 to say that it can depart from that decision. And for that reason, Your Honor, I believe that that is probably the first and most fundamental error in which the Court of Appeal fell in terms of a miscarriage of justice. It ought to have followed that decision. It had no basis to do so otherwise. Now, Your Honor, in that decision, and I now move to the crux of the decision, there were certain statements that were made in the law which impact wholly and solely upon what we have before us. In short compass, two of the judges declined jurisdiction, and the third judge, while accepting jurisdiction, decided that the matter was of such a nature that it would stretch the meaning of the articles in question. And in this regard, I wanted to very quickly adopt what the learned Attorney General said in relation to the decision of Justice Japan. Because Justice Japan, and I don't want to rehash it, the quote that the learned Attorney General used was this, and this is at the top of page 135. An examination of the supporting affidavit to the motion does not disclose either of the two reasons specified in Article 177.4. Again, Mr. Jonas has canvassed that quite extensively, and I adopt that submission that when you look at the affidavit, it does not canvass in any way, shape, or form any of the two limbs that have been set out in 177.4. And then it goes on to say, this article gives this court power to try matters relating to these two issues and no more. So if it is that this has been the determination of the apex court at the time, it was not, most respectfully, open to the Guyana Court of Appeal of 2020 to do otherwise than to follow this. It is also important, Your Honor, to note that in the dissenting judgment of this particular case, even though Chancellor George, as he subsequently became, was adopted a position of accepting jurisdiction, this is what Chancellor George had to say, even though he accepted jurisdiction. He said to the effect that having regard to what was being required, and in that case, it was a question of whether or not the oath of office was validly taken. He said that, he said, and I'm paraphrasing, I can find the quotation. He said in effect that to stretch the uses of the word interpretation to bear a meaning in accordance with section 10.1 of the Act was not something that was credible or valid. And it is for those reasons that, notwithstanding that he assumed jurisdiction, he nonetheless dismissed the appeal with costs. So that, Your Honors, the twofold submission arising out of UC Guyana is that if the court first and foremost ought to decline jurisdiction in accordance with that dicta, because that dicta is now from a concurrent jurisdiction as the Caribbean Court of Justice. And secondly, in the alternative, if it chooses to assume jurisdiction, then it ought to, in the circumstances, rule along the lines of Justice George and that dicta, that to stretch the meaning of interpretation of the Constitution to somehow include some discussion as it relates to 177.2b would not be sui generis, and therefore the court ought not to countenance that, and for that reason, it should similarly dismiss the application. Your Honors, I wanted to canvass the second aspect of the decision of my submissions had to do with the wide panoply of powers that have been granted in the Constitution. And again, I wanted to refer to UC Guyana and the dicta of Justice George, Justice Japan, when he told the court rather trenchantly that the Constitution is, quote, a self-contained document, end of quote. If the Constitution is a self-contained document, then in order for us to understand what the Constitution means, what it pertains to, how it is to be interpreted and understood, we have to first look within the four corners of the Constitution. And in that regard, Your Honors, I refer you to my submissions at page, I believe it is paragraph 16 of those submissions. What I have done in short compass is set out the layers upon which qualification is determined. First, you have to qualify under Article 90. Article 90 then says subject to Article 53, I believe. And then Article 53 refers you to 155. And it lays out in very plain terms a wide range of qualifications. Nowhere in any of these qualifications do you find anything related to the validity of votes. It is clear that because our Constitution is set up in such a way that in order for you to be designated a presidential candidate, you would first have to have qualified to be a member of the National Assembly and to be on the list. So that it follows that if you did not qualify to become a member of the National Assembly, or if you did not meet those qualifications, then you could not be designated as the presidential candidate. There's a wide sweep of powers which I don't propose to go through in my submissions that speak. There are at least in excess of 25 different qualifications. None of them say anything about the validity of votes. None of them say anything about the matters which are being complained about by Ms. David. So if one were to look within the document, the Constitution that is, you would find clearly that what you have before you is a document which has tried as best as it could to ensure that every single possible alternative, every single qualification as well as disqualification was contained in this document in a way that left no doubt as to how you determine who gets into the National Assembly and ultimately who becomes the presidential candidate. And it is for those reasons, Your Honor, I believe that going outside of that document in order to determine it, having regard to the dicta in UC Guyana, that it is a self-contained document, was part of the reason why the court respectfully went into error. Your Honor, on the issue of jurisdiction, I wanted to canvass a little bit with your permission, a little bit about how Guyana, and I believe that this has been mentioned before, but I believe it is important to understand where our electoral system has come from and why it is we are where we are. Your Honor, what we have essentially is the continuation of a Westminster system. We have a situation in Guyana where there are no direct elections for the president. We have, since the adoption of the 1980 Constitution, fused the position of head of state and head of government. What you have, in not dissimilar fashion as, let's say, the rest of the Commonwealth Caribbean, is elections are taking place in a constituency basis. We have, of course, proportional representation. But at the end of those elections, a decision has to be made by the head of state, the Governor General, as the case may be, to decide to invite the person who commands the majority in the House to form the next government and to effectively become the head of government. That function has now been given, so to speak, to the elections machinery. And therefore, Your Honors, what we have before us is circumstances which are not the same, but they are akin to what takes place in the rest of the Commonwealth Caribbean. In that there is no direct election for a prime minister, and similarly, there is no direct election for a president. What you have is a tabulation which then determines, on the basis of that tabulation, who is going to become the president. And when we look at, for example, I use this very briefly, the Constitution of Trinidad and Tobago, Articles 76, 1 and 2, we see that the members appointed to the House of Representatives are then considered as to which party is likely to command the majority of the House. We don't have that kind of system, but it is obvious that in the use of the words more votes cast, it is interpretive of the fact that this person who is listed as the presidential candidate is likely to have the majority and hence the command of the House. There is, of course, the fallback position that if you don't get the majority and you end up with a plurality, which is what obtained in 2011, you can still nonetheless be elected the president of Guyana. So that for those reasons, and then when we look at the entire construct of the Republic, the Representation of the People's Act, we're at a situation where this court is being asked to make a determination on an issue which for all practical purposes has not yet arisen. There's been no declaration. There's been no deeming. There's been no extraction. The entire construct of the Representation of the People's Act is of such that that process is a necessary precondition towards getting to the point where somebody gets elected. We are not in that position as yet, which is why I believe the submissions as to the premature nature of this action are well grounded. Your Honor, finally, I wanted to deal with the issues that were raised by some of the issues that were raised by my friends as it relates to the submissions that have been made. And then I will conclude by responding to the questions issue by issue. Now, Your Honor, it was mooted that we don't have any reference to the Caribbean Court of Justice in our Constitution. And I wanted to go back a little bit because when you look at the CCJ Act was on the basis of an agreement signed in 2001. Our Constitution was the subject of comprehensive amendment in 2003. And clearly, those who sat on the Constitution Commission understood that the treaty obligation already existed. And I wanted, Your Honors, in particular, to pay attention to the wording of Article 123(4) of the Constitution, because this is what it says. Article 123(4) says this: Parliament may make such provisions as it deems fit, authorizing any court established or to be established as the final court of appeal for the Caribbean to be the final court of appeal for Guyana. And it goes on further to say that where a court referred to, this is paragraph 5, where a court referred to in paragraph 4 is established and becomes the final court of appeal of Guyana, such court shall remain the final court of appeal of Guyana unless Parliament, by a vote of no less than 2/3 of all elected members, makes provision for Guyana to withdraw from such court. End of quote. Your Honor, it is clear that the framers of the Constitution in 2003 had already made provision consistent with the treaty obligations that were signed on by Guyana in 2001. So when the court came into existence in 2005, the platform in the Constitution. So it is not entirely accurate, Your Honor, to say that the Constitution does not provide for the Caribbean Court of Justice. Your Honor, the other issue that was raised, which I would like to address, is this: that we are placed in a situation where much of what is being canvassed before you has really nothing to do with the actual issue at hand. You have heard submissions which are wide-ranging, which touch and concern many different matters. I would be the first to admit that it is probably incredibly boring of you to have to look at these things having regard to what is strictly before you. But I believe that this court is seized with a higher obligation. I believe that this court cannot simply, in light of what is taking place in Guyana and how events have been unfolding, to simply say in its deliberations that we are simply minded to deal with the legal issues. I would ask this court to take a more broad, purposive approach to its deliberations. Unlike my friends, I will not ask the court for any specific orders, but I would ask the court to make such orders that are reflective of the spirit and intent of the formation of this court, and to be consistent with what is taking place on the ground. My clients, Your Honors, did not get more than 1,000 votes out of 460,000. They're not going to be represented in the National Assembly. They're not going to be anywhere near the seat of government. But they're nonetheless here because there are very real concerns and there are very real dangers that touch and concern every single Guyanese, regardless of whether or not they voted for or against. And therefore, it is on this platform, on this premise, that I urge this court to give as broad and as purposive consideration as is judicially possible in order to effect real change to what is taking place in Guyana. Finally, Your Honors, for the purposes of completion, I wanted to look at the issues as presented and provide some answers consistent with what it is the court has asked us. Principally, Your Honors, it is my contention that the Court of Appeal, for the reasons given in UC Guyana and the other reasons, lacked jurisdiction. And as a consequence, this court ought to allow the application for special leave and discharge the entire proceedings that have taken place before the Court of Appeal, that is. That would touch and concern issue 2, I believe. Issue 3, if the court does find jurisdiction, I believe the court should, along the lines of the dissenting judgment of Justice George in UC Guyana, find that having regard to the interpretation that is being asked or that was asked of the Court of Appeal in relation to 177(2)(b, that it represented a stretch to the degree and extent that it did, that in the words of Chancellor George, it is not capable of bearing a meaning that is being ascribed to it. And I'm speaking here specifically about the second part of 177(4). And therefore, if it is that the court finds jurisdiction, then I believe that the court ought to nonetheless dismiss the application before the Court of Appeal. Finally, Your Honors, the court has asked us to say whether or not it is found that the court acted in excess of its jurisdiction, what would be the consequences? Your Honor, in like manner as issue 3, the consequences would be that any decision that is made by the court in excess of its jurisdiction are ones that are likely to be vacated. And for these and the other reasons which I have canvassed in my submissions, I would ask the court accordingly. I am most grateful to the court for the opportunity to have been heard this afternoon. Thank you.
Yes, thank you very much, Mr. Khan. Mr. Amor, it's your turn.
Thank you very much, my lords. Afternoon, my lords and my ladies. Well, I am going to follow the construct of our written and attempt to summarize and highlight certain aspects of it within the structure of jurisdiction and merits. Jurisdiction, my lords, your honors. The Caribbean Court of Justice is not a court of unlimited jurisdiction. I cannot stress that too much. The Caribbean Court of Justice is a regional apex court presiding over signatory sovereign member states, and that court derives its jurisdiction and powers solely.
Mr. Amor, if I may, we're getting just a little static, a little difficult with your audio. So I think
I'm happy to,
if you could turn off your video.
Indeed, yes. I will, Milad. Happy to do that. Thank you.
To my great unhappiness, Mr. Amor, but we will bear with it.
Thank you, my Lord Justice Barrow. So, just to recap briefly, I'm going to deal with jurisdiction and merits in the same manner in which I dealt with in the written submissions. The Caribbean Court of Justice is not a court of unlimited jurisdiction. It is a regional apex court presiding over signatory sovereign member states and derives its jurisdiction and powers solely from the terms of its formative treaty, that is to say, the agreement establishing the Caribbean Court of Justice. Are my lads hearing me?
Yes.
Yes.
Yes, thank you. Accordingly, any consideration as to whether this court has jurisdiction on this intended appeal must start, we submit, and ends with the true interpretation of the terms of the agreement, and in particular, Article 25(5), when read alongside the Caribbean Court of Justice Act 2004 and the Constitution of Guyana. This consideration is paramount and must take place from an international law perspective, notwithstanding that we are sitting in the court's appellate jurisdiction, since the interpretation of treaties requires the application of different legal principles from those applicable in domestic courts. The court must therefore look to Article 31 of the Vienna Convention on the law of treaties, as it has done many times before in its original jurisdiction. And I cite, for example, Trinidad Cement Limited and Guyana 2009 CCJ 1, a copy of which I have asked to be uploaded to the system, really for the assistance of my learned friends who appear for all of the parties before you. I have no doubt that your lordships are very familiar with that decision. I do not need to dwell on it. I simply say that I rely without more and without the need for any repetition on paragraph 10 of that decision as to the applicability of principles of international law in determining your jurisdiction under the agreement as to whether or not you have jurisdiction to entertain this appeal, which I submit with respect you do not have. As consistent with Article 31 of the Vienna Convention, Article 25(5) must be looked at for its ordinary meaning in accordance with its context and the object and purpose of the treaty as a whole. The applicants have submitted that the use of the word decision in Article 25(5) must be interpreted to mean a decision which the Court of Appeal has jurisdiction to make. We submit, my lord, that this is plainly not consistent. This approach is plainly not consistent with the ordinary meaning of the words utilized in Article 25(5). The onus was on the appellants to show that the context of Article 25(5), along with the object and purpose of the agreement, supports the interpretation for which we contend is the applicable interpretation. We submit they have failed to do. Rather, the applicants have advanced domestic law concepts drawn from authority.
I'm sorry to interrupt you. Could I just clarify something, please? Are you saying that the use of the word decision must mean a decision that the Court of Appeal has jurisdiction to make? That's what I thought I heard you say. I'm just trying to clarify.
That the use of the word decision in Article 25 is what I'm referring to. I have not as yet addressed the Court of Appeal's decision, but it will include any decision of the Court of Appeal as the final court of appeal domestically for Guyana. Yes.
So what I'm asking is it accurate that what you are saying is the use of the word decision in Article 25(5) must mean a decision that the Court of Appeal has jurisdiction to make? Is that what you're saying?
I'm not saying that, Millard. And if your lordship would allow me to develop the point, because I'm coming to address it more fully, if I might, please. Thank you. So I was at the point of saying that Annie's Minnick and Lee and Asher's Bakery are not helpful because those authorities do not go to the proper interpretation and application of the agreement, the treaty, which interpretation and which treaty this court cannot avoid adhering to. What does assist the court is an examination of the object and purpose of the agreement. So, for example, the preamble of the agreement expressly recognizes the sovereignty of member states. And one of those member states, of course, will be Guyana. So the second preamble says, convinced, the last preamble says, recognizing the sovereignty of members of the Caribbean community. So when you come to interpret the word decision in Article 25(5), you have to take it in the context and meaning of the agreement. Within the frame of that agreement, you have to take into consideration the preeminence of the sovereignty of the members of the Caribbean community, which have come together consensually to give jurisdiction to this court to be the apex court for the member territories. You also have to be guided by the fact that the preamble speaks, convinced also of the desirability of entrenching the court in their national constitutions. The objective, therefore, is to respect the supremacy of the Constitution. In this case, Millard, the supremacy of the Constitution of the Cooperative Republic of Guyana is declared as the supreme law of Guyana, and if any other law is inconsistent with it, that other law shall, to the extent of that inconsistency, be void. And Mr. Khan has just very usefully reminded us of Articles 123, sub-articles 4 and 5 of the Guyana Constitution. The point there being that by the treaty which creates you, from whose womb you have sprung, with the consent of the sovereign members who have created you, you are entrenched within the Constitution of Guyana, and you are to pay regard to Articles 8, Article 123, sub 4 and 5, Article 177.4, and we will get to that. It is not without significant note that in the debate and passage of the Caribbean Court of Justice Act 2004, that act was passed unanimously by the Parliament of the Sovereign Cooperative Republic of Guyana, one of that republic's under Section 50 of the Constitution, one of that republic's supreme organs of democratic power. The primacy of the Sovereign Cooperative Republic's indigenous Court of Appeal was explicitly recognized, lauded, and expressly preserved as final. And this court, the CCJ, was incorporated by Parliament into the fabric of the domestic law of Guyana and expressly told it had no jurisdiction, it has no jurisdiction as decreed by Article 177.4 of the Constitution. It is significant, Millard, when we look at the debates which were taking place in Guyana, when those debates were taking place in 2004, and that's tab 1 of our tabs to our written submissions, that when that matter came up for debate on the incorporation of the agreement to make this court part of the domestic law, the language of the lead proponent of the bill, the Honorable Attorney General, Mr. Do Not Sing, Senior Counsel, and other members of Parliament were very clear in acknowledging, and we repeat that, and I don't need to spell it out now, the language that was used in the bill, which in the passage and the debate on the bill, which recognized the finality and the exclusive jurisdiction of the Court of Appeal of Guyana, even whilst this court was being entrenched as the apex court. Now, it is significant, Millard, and noteworthy that at the very point of the conclusion of the agreement in 2001, the Privy Council had already determined in the Senanyake case, 1954, which is referred to in the first respondent's written submissions and has been referred to by my learned friend, Mr. Jeremy, and I'm not going to repeat anything that he has said, but it is significant that that case, as far back as 1954, already pronounced the Privy Council that it could not entertain an appeal from an election court, even on jurisdictional grounds. I'm not going to repeat, and the case is there, but I commend recommend it for your lordships very carefully. The Privy Council revisited that case in 2011. A 1954 case was revisited in the Dana Sylvie Mary case, again referred to in the first respondent submissions. And therefore, it is significant that in 2001, when we are looking to context, when we are looking to object and purpose of the incorporation of the Caribbean Court of Justice as part of the domestic court system of Guyana as its apex court, the framers of the agreement were recognizing even back in 2001 the context and the history in which they were proclaiming Article 25(5) of the agreement. Compelled your lordships without any doubt, and your lordships will just forgive me for a moment while I pull my papers together. The language of Article 25(5) is very clear. Nothing in this appeal shall apply, nothing in this article, I beg your lordship's pardon, shall apply to matters in relation to which the decision of the Court of Appeal of a contracting party is, at the time of the entry into force of the agreement, pursuant to the Constitution or any other law of that party, declared to be final. And we submit respectfully that it is indisputably part of the context, the object, and the purpose with which this court must acknowledge coming out of Article 25(5). Indisputably, therefore, in context, the framers of the agreement, that is to say, the sovereign member states, including the Cooperative Republic of Guyana, must be presumed to have known that by including Article 25(5) in the language used would, at the very least, in relation to election matters, harken back to Senanyaki in 1954 and all the cases that come from there, that the jurisprudence of the constitutional construct in relation to election matters precluded appeals beyond the domestic indigenous Court of Appeal of the jurisdiction. That is the context within which Article 25(5) has to be construed. And
Mr.
when you look
Mr. Amara, just pause for a minute. I think you mean, I think that means, just to be clear, I think you may agree that that means in relation to the President 177(4). Is it correct that in relation to challenges to the Assembly, validity of votes under the RPO, you have first to go to the High Court, then to the Court of Appeal, and there is no bar to the CCJ?
Well, Section 166.
In other words, I'm asking a simple question.
You've
stated the bar in an absolute sense. You said that the whole point of Article 25(5) is all election matters are to be finally disposed of by the indigenous courts in Guyana. I'm simply asking, is that submission in relation to the elections for the Assembly or only for the President?
My lord, the fault is entirely mine if I have been less clear than I should be. I am speaking of Section 177(4). I am speaking the decision of the Court of Appeal in this matter, which is on appeal to your lordships, which has come to your lordships under Section 177(4), and the question before your lordships, and that's all that I'm speaking to, is the jurisdiction of the Court of Appeal. I am not at this point in time referring to Section 163 as I develop the argument, and it is developed in our full written submission. Of course, we accept, Millard, that there is a rule for election petitions under Section 163, and that is spelled out. All I am on is the last.
So, Mr. Amara, may I just, interrupt you a little bit more? Under that other route, just to get an answer to my question, that review process ends in the CCJ.
The review
can end in the CCJ. Jurisdiction.
Through Section 163, my lord, the review process ends in the CCJ, yes.
And that
But
review process, can include a challenge to the validity of votes, the normal election petition stuff. Mr. Amara, are you hearing me?
I've lost Millard. I'm sorry. No, Millard.
Right.
I've lost you too.
I was asking, and that
Yes.
review process includes a review by the High Court as an election court of validity of votes, all the stuff that is covered usually in an election petition. What votes are valid, what votes are invalid, whether they're spoiled ballots, all that stuff. All of that stuff can be reviewed in the High Court election court and reach the Privy Council and reach the CCJ. Agreed?
Yes, my lord.
So can I ask you a question? Let us assume
Hello.
what I want to ask you a question. Are you hearing me?
Yes, yes,
hearing
my, sorry, I forgot that I was not on camera. So I was nodding in acknowledgement of the fact that I heard your lordship say that you wanted to ask me a question. My apologies, my lord. Yes.
Neither one of us is on camera, so we are both equally disabled, I imagine.
Well, as my old teacher would say, my lord, à haute voix.
There you go. So what I want to ask is this. Let's assume we've read your argument. So let's assume that you are right. And the Court of Appeal has this exclusive jurisdiction in relation to the president that can't go anywhere else. Right? Good. If an election petition is brought in the High Court, in this case, to challenge the validity of the votes, and it can end in the CCJ, can that result in the CCJ giving a decision that may be contrary to what the CEO has decided under the exclusive jurisdiction that the Court of Appeal has carved out? Is that a possible occurrence under this two-tier system that you advocate for?
Well, that is a point that I have actually included in the submissions that I'm making this afternoon. I wonder whether your lordship would allow me to develop the submission a bit more, and I will certainly address that because it is a point I'm actually speaking from a speaking note, which I have prepared, and I have developed that point a little further on, if I may be allowed to. Obliged. Thank you, Millard. So that I was at the stage at which I was saying, Millard, that the context in which Article 25.5 was constructed and the language of Article 25.5 is to be taken as understood by the framers of the Constitution from a plethora of cases coming out of the Privy Council, going back to 1876, and your lordship will see a lot of those cases in the judgment of Nyanyake, Thurburgeon Laundry, Strickland and Grima, and a number of other cases coming right up to the decision out of the Caribbean, out of the Eastern Caribbean Court of Appeal, named Janice Pereira, Chief Justice, in the Hector John matter, which is tab 4 in our written submissions. And in fact, the very authorities of Petrie and Punaswamy, relied on by my learned friend, Mr. Mendez, support the contextual construction that I am advocating for that would have been known to the framers of Article 25.5 in the agreement which birthed the Caribbean Court of Justice. And one would therefore be entitled to expect that should the agreement have been intended to create such a radical departure from the historical context of how election matters have been treated historically in courts of final jurisdiction, courts of appeal of final jurisdiction, not going to the Privy Council, then one would have expected clear and precise language to have been used, far different from what is used in Article 25.5. And this is so even more where the law has developed significantly since Annis Minnick. So it is our submission, Millard, that in 2001, the framers of the agreement must be presumed to have known that there was an option available to specify that appeals must lie against decisions expressed in the constitutions of sovereign member states on jurisdictional grounds and to be final. Had they so intended, the language of Article 25.5 would necessarily have been different. And I've referred to, and I emphasize, the language of the parliamentarians in the Parliament of Guyana when they were debating the legislation, the Act, CCJ Act of 2004, that created the CCJ and gave validity to the treaty as part of the domestic law of Guyana. The short point there being, Millard, that the language of 25.5 as worded must be taken to be what it is, deliberate and intentional. Millard, I've referred to the Hector John case. It speaks to the electoral process, an election being at the end of the day a process through which the exercise of the democracy and of the electors of the sovereign nation members who have birthed the election, the agreement, speaks to the process of elections. I'm not going to dwell on it, but I commend that case for your lordships. And therefore, I say, my lords, that when the matter is considered properly and in the round against Article 31 of the Vienna Convention on the Law of Treaties, we submit that the inescapable, unavoidable conclusion is that the agreement did not intend to vest the CCJ with discretion, with jurisdiction to hear this particular type of appeal under Section 177.4. This is so given A, the ordinary meaning to be given to the language of Article 25.5 in the context comprehensively manifested in the jurisprudence existing at 2001 and presumed to be known to the framers of the Constitution, read against the object, framers of the agreement, beg your lordship's pardon, and read against the object and purpose of the agreement as set out in its preamble, and presumed to have been intended in 2004 by the Parliament of Guyana when it received the Caribbean Court of Justice as its apex court by the passage of the bill which became the CCJ Act 2004. Sorry?
Yes, go ahead, Mr. Amo.
Thank you, my lord. So that without more, my lord, we say that this application to appeal, having regard to the language, the intent, and the frame of your enabling treaty agreement, cannot be entertained and for want of jurisdiction must be dismissed. When we turn to the merits, my lords, I will be brief without repeating much of what we've said. We say that for this court to set aside, without prejudice to our agreement or arguments on no jurisdiction, for this court to set aside the decision of the Court of Appeal, you will have to satisfy yourself that the Court of Appeal was plainly wrong. The case on the language and the reasoning process of the decisions which we now have. The court did nothing more than interpret the constitutional provisions, Article 177.2b and Article 177.4. That the Court of Appeal was right to engage in the interpretative exercise which Section 177.4 allowed them with reference back to B of the relief that they were asked to give, that is to say, an interpretation exercise. Article 173, Millard, does not permit the total exclusive jurisdiction. 163, sorry, beg your lordship's pardon. The question of the interpretation of a constitutional provision insofar as the election of the president depends on the interpretation within Article 177, and the election of the president must depend on an interpretation of that article, 177.2b, 177.4. Proceeding, therefore, on the basis that the Court of Appeal was competent under Article 177.4 to interpret Article 177.2b as it did, the question then becomes whether the Court of Appeal exceeded that jurisdiction. We submit it did not. The Court of Appeal did not perform any assessment with regard to determining the validity of an election, such as establishing criteria by which votes are deemed to be valid in accordance with Order Number 60's requirement of a final credible account. Indeed, the president of the court, Madam Justice Gregory, Justice of Appeal, made it clear that the court did not have jurisdiction to determine the validity of the contents of the CEO's report. See paragraph 36. The Court of Appeal properly stayed within its constitutional remit. In terms of Article 177.4, in terms of the argument that Article 177.4 is only triggered upon a declaration of an elected president, this interpretation is not consistent when you read Article 177 as a whole. Again, as expressly recognized by Justice of Appeal Gregory, Article 177.2b speaks to the machinery set out for the election of a president. Paragraph 31. The use of the word election, simpliciter, in Article 177.4 can only logically be construed on a purposive interpretation to encompass the entirety of the election process as correctly explained by Dame Janice Pereira, Chief Justice, in Hector John, and from Article 177.1 through to Article 177.6. Article
so
177.
just now, Mr. Amos, so you agree with Mr. Jeremy, I take it, or was it Mr. Jeremy, I think, that 177.4 can be triggered at any point in the electoral process. Is that it? From the time there is a nomination made and someone is at the top of a list, which I think it might be some days before the actual election day. 177.4 can be triggered.
I agree it can be triggered, but it is not in the interpretation of a constitution which one has to interpret as a whole. One has to look at the constitution in the round. And this brings me to the question which my learned friend, not my learned friend, I beg his lordship's pardon, Mr. Justice Jamadar was asking me a moment ago about section 163 of the Constitution. There is 163 and there is 177. We are at the moment concerned with 177. But it was very interesting that Mr. Ramkaran, who preceded me moments ago, actually applied to this court, and it was illustrative of the path that is being, and I say this respectfully to my learned friends, and I say it respectfully to Mr. Justice Witt in particular, who has had some very interesting questions. Mr. Ramkaran's intervention revealed an interesting path that this appeal has taken. Here we are in an appeal from a decision of the majority of the court on an interpretation of section 177.4 and 177.2b to determine the meaning of valid votes. And Mr. Ramkaran, as did Mr. Mendez, has gone through the entirety of the reliefs which was sought by the applicant, which were not given, which were not prayed and given by the Court of Appeal. And one could be mistaken to think that all of those reliefs were rendered because the appeal is speaking outside of the remit of the appeal. In his argument this afternoon, Mr. Ramkaran allowed himself to say to the court, and in particular to Mr. Justice Witt, that he was exhorting the court to look at the bundle of material before it now, and indeed to declare on this election. Now, what that highlights, and it has to do with section 177.6 of the Constitution, is that there is still a process to be engaged. That is to say, beyond the decision of the Court of Appeal, which has said what votes mean within the meaning of the Constitution, there is still a point at 177.6 when a president will be declared. At that stage, when a president is declared, whoever he or she may be, it will be the opportune moment for much of the discussion that is taking place in this appeal today, and I say respectfully, impermissibly, about what the chief executive officer did after the decision of the election, about what was done in relation to other matters that don't arise from the appeal. Much of Mr. Mendez's submissions speaks to things that have happened since the appeal was determined and the Court of Appeal gave its decision. The point is that all of those allegations that have been made will properly arise after a declaration is made with the guidance of the Court of Appeal, whose decision we say is final, and then an election petition may be brought through the pathway of Section 163, and all of the arguments will come back, as Mr. Ramkaran cautioned the court this afternoon. Those arguments will come back to this very court, permissibly through the route, and this is to address Mr. Justice Jamadar's question of me, permissibly through the route of an election petition under Section 163, then to the Court of Appeal, and then permissibly through to the Caribbean Court of Justice as the apex court, which has jurisdiction in relation to the limited aspect of election petitions that will be allowed by special leave. That is the route. But at this stage,
please, just pause for a minute.
That, Mr. Justice,
Section 177,
yes.
The process is a demon process. That is to say, the votes that are, let's use the expression, valid votes after this election petition 163 process are determined properly, you say, fair enough. When that, if the result is different from what has been declared, will that not then have a consequential effect on who is to be president because of the demon provision in 177? In other words, to be practical.
I'm sorry, couldn't ask me just to repeat that. You broke up there for a moment, Milan. I apologize.
So let's follow your train of thought. This remains as it is. Somebody says X votes have been improperly disqualified or considered invalid. It now goes through the process of 163. And at the end of that process, the voter count, the valid votes, is different from what has been done. That will have an effect on who is to be president because of the demon section in 177. Agreed?
I would accept that for that, yes.
Fair enough. Now, equally, the effect of what is being done now, before any process of review, has a retrospective, I say retrospective, and I'll tell you why, a retrospective effect on the composition of the assembly. Because if through this process under 177, and I'm not trying to be wedded to figures, I'm not trying to say this is true or not. If 100,000 X votes are now declared invalid, that must have a retrospective effect on the composition of the assembly immediately, because it cannot be that for the assembly you have 300,000 valid votes, let's say, but for the presidential election you only have, I'm just using figures off the top of my head, forgive me, 150,000 valid votes, because that would make an absolute mockery of the electoral system. So that what you would end up with is, pursuant to 177 and what we know are the facts, there is now an implied demon effect on the composition of the assembly. Has to be. What happens to the assembly? Let's suppose this decision is final, you are right. And let us assume that it ends there. What does this have? What is the effect in law on the composition of the assembly right now?
Well, Milad, I will attempt to address that in two parts. First of all, Milad, as I understand the orders that have been made, is they hearing me?
You're breaking up a little bit, but go ahead. We will see.
If I understand Milad correctly, the Court of Appeal did not declare any votes to be valid. The Court of Appeal has given an interpretation on.
I accept that. No, I am, yeah. Mr. Almara, I am accepting for the moment what you say. I'm not trying to challenge it. I'm saying, what is the consequential effect the composition. Suppose this is not challenged any further. What is the consequential effect on the composition of the assembly?
I don't know, Your Honor, I don't know that that is a question that I can assist your lordship with the greatest of respect.
No, but Mr. Amo, it's a very important question, you see, and it is a question that must naturally.
Not hearing your President.
It is a question that must naturally and inevitably arise from the moment you decouple Article 177.4 from an interrogation of the election of a particular person as president. In other words, if, as your side, and I say your side because you are arguing along the same lines as a number of others, if it is that 177.4 can be triggered when no one knows who is the individual whose invalidity, whose election is being challenged as being invalid, then it must mean that you are applying 177.4 not to a person who you say has been invalidly elected, but you are applying it to a process or to a system or to a machinery. The problem is that it is that same process, that same system, that same machinery that is necessary for membership of the National Assembly. The Constitution says that the High Court has exclusive jurisdiction to interrogate questions relating to that process, to that system, to that machinery in relation to membership of the National Assembly. Once you decouple Article 177.4 from the interrogation of a particular person as an invalidly elected president, then you are saying that 177.4 also gives the Court of Appeal an exclusive jurisdiction to interrogate that same process, that same machinery, that same system as 163 gives to members of the National Assembly. How can a constitution provide exclusive jurisdiction to two different courts to address or to interrogate the same process, the same system, the same machinery?
Well, the answer, that the best answer I can give to that is one has to A, construe the language of the Constitution as a whole so that there is no inherent contradiction that the Constitution can have intended as between Section 163 and 177.4. And there is case law that we have put before your lordship to demonstrate, and the language of that case law says that you have to construe a constitution in terms that the Constitution is not self-contradictory. The framers of the Constitution put Section 163 in there while at the same time put in Section 177.4 in there. And they must have intended by that to have each of those sections apply to a different state of affairs.
And this is precisely the point, Mr. Amo, that the only way that they can be reconciled with each other is if 177.4 is addressing the invalidity of a particular person who has been elected as president.
Well,
That is the only way the two can be reconciled.
I would say with respect, Miller, that I'm not able to agree with your lordship respectfully that 177.4 can only be construed to mean a particular person, because the language of 177.4 is within the context of 177 in its entirety. 177.2 tells us that there can be more than one presidential candidate, and 177.4 gives exclusive jurisdiction to the Court of Appeal to hear and determine any question as to the validity of an election of a president, not the president, or not one or other president, so far as that question depends on the qualification of any person for election. So it is part of the process, in my respectful question that's been asked.
Is there a president now other than President Granger?
Not that I'm aware of, my lord, no.
I see.
All right, Mr. Amra, just before we move off of this, I just want to clarify in my own mind something. So that we have to, I agree with you, we have to find a way to make sense of the Constitution. You advocate for a contextual interpretation so that all these cases and so are precedents. Are any of the jurisdictions from which these cases come, cases in contexts, political contexts, in which the particular hybrid system in Guyana, in which the president is appointed on a deeming basis of votes cast at a single election? So that's one question. Do any of those cases come out of that context? You advocate for a contextual interpretation, one. Two, on what we were speaking about earlier.
Answer the first question, not that I'm aware of, my lord.
Not that you're aware of. Okay, and therefore we have to discover, I think you will agree, in this particular context, bear in mind, precedents are only useful as examples in their context. We extract some principles from them, but ultimately we have to make sense in this indigenous context called Guyana and its hybrid system. Good. Two, the path that we have discussed, which leads to the Court of Appeal having exclusive jurisdiction to decide, to by implication decide the outcome of the Assembly, and the Assembly's election can also end up at the CCJ. Do you think that that can potentially result, since the Court of Appeal has final and exclusive jurisdiction over the president, there is a retrospective effect on the Assembly, and the Assembly's election ends in the CCJ, that you can have potentially different decisions on the same point? That is to say, the constitution of the Assembly, constitution meaning how it is composed, the makeup of the Assembly. Maybe I should be practical. In this case, the final decision of the Court of Appeal, the effect of it is we have to reduce the number of votes for the calculation of the Assembly by 100 and something thousand, we are told. Right or wrong, I'm not sure. That same process comes to the CCJ, and the CCJ says, no, hold on, we think the only spoiled votes are 50. Can that not potentially result? How do you resolve the composition of the Assembly with that? Which court's decision is final and authoritative?
My lord, there are a few things I'd like to say in answer to your lordship, and before I forget, your lordship will remember at the beginning I had said that there were two objections that I wanted to make, and I would state them now because they're relevant to how I answer your lordship's question. One of the objections that I put on record is that it is impermissible, in my respectful view, for the court to permit itself on this appeal to be engaging questions with reference to factual events that the intended appellant has put before this court, of events that took place after the election, after the Court of Appeal decision. That is no part of the remit of this court, either to be dealing with on the appeal as to whether the Court of Appeal was right or wrong to rule as it did on the proper interpretation of Section 177 2B. In fact, at the administrative hearing we had here, I believe that Mr. Justice of Appeal, sorry, Millard, I'm not sure if I'm interrupted by Millard. I don't wish to be rude. Yes, I was saying, thank you, Millard. I believe that Mr. Justice of Appeal Anderson had remarked on the fact that questions were being raised about the so-called 115,000 votes that had been so-called spoiled or removed. Those are not matters, in my respectful view, that this court should be engaging on. Far less.
Mr. Amara, I'm sorry to interrupt you. I am not on the numbers, I'm on the theory.
Exactly where I was going to make the point that it is not, in my respectful view, permissible for the court to allow itself to be led into error on a hypothesis based on impermissible evidence that has been put before this court about things that have happened since the election. That's my first point of objection to evidence that has been put in on the affidavit of the intended appellants and on submissions that my learned friend Mr. Mendez has made concerning matters that were before the Court of Appeal on the motion, which the Court of Appeal on their written judgments have clearly turned down, and yet we are arguing this appeal as if the Court of Appeal granted all of the reliefs that were asked for by the appellant. We have to limit, with the greatest of respect, this court has to limit itself to what is before it on appeal, and that is the orders that were pronounced on valid votes, and in my respectful view, either determine that clearly the Court of Appeal was plainly wrong or not plainly wrong. And particularly and precisely because of the kind of conversation that we are having now about the sui generis nature of the Guyanese constitution, I submit with respect that this court, even if you may not agree with what the Court of Appeal did, it is not a case in which you can pronounce that the court was plainly wrong. And therefore, if I could turn to the questions that were asked of us in relation to the issues that we were asked to address, we've dealt with them in paragraph 23 of our written submission, Millard, and I will repeat them as I come to the end of my submissions. I say that on paragraph 23, if I could just be allowed to find my submissions, we say on the first issue, whether the Court of Appeal had jurisdiction to entertain the motion filed by Eslyn Davis, we say the Court of Appeal had jurisdiction. B, if the Court of Appeal lacked jurisdiction, what is the consequence in relation to this proposed appeal? We say respectfully none. The Caribbean Court of Justice under 177.4 is not vested with jurisdiction to hear this appeal under its enabling treaty. And I'm not going to repeat my submissions in that regard. C, if the Court of Appeal rightly assumed the jurisdiction, what is the consequence in relation to this proposed appeal? We say, assuming that the Court of Appeal, the CCJ incorrectly, with respect, arrogates jurisdiction onto itself to hear this appeal, then the appeal would fall to be dismissed with costs once the Court of Appeal is found to have rightly assumed jurisdiction. And we say that it is not possible in our respectful submission for this court to say on the material before it and in the context of the peculiar language of Section 177.4 counterpoised to Section 163 and read in the Constitution as a whole, for this court to say that the Court of Appeal was plainly wrong. Lastly, we say the Court of Appeal rightly assumed jurisdiction, but they exceeded their jurisdiction. What is the consequence in relation to this proposed appeal? Again, we say respectfully none. And if I may just come to the end of my submissions, Millard. We must not forget, and here I'm grateful to my learned friend for the first respondent for the history that he has traced of Guyana's legislative and judicial history. We must not forget that Article 177.4 has formed part of the legislative history of Guyana since the Independence Constitution of 1966. And as such, my lord, clear words, if it was that the framers of both the treaty and of Article 177.4, clear words would have had to have been utilized if the framers had intended that there should be a different reality to the finality of the Court of Appeal as the final indigenous court on matters of this nature. So if I may come to the end of my submission with your lordship's leave. My lord, this is a difficult case. I make no apologies when I say it is. I would not like to be in your lordship's seat to determine this case. It is a truism, and I offer this truism with apology because I mean no disrespect. Hard cases make bad law. Your lordships must be very slow, very deliberate, and very careful to approach this case carefully within the context of the Constitution and your treaty to determine the correct legal interpretation to be given to your treaty in relation to the jurisdiction and to 177 in relation to the section under which the Court of Appeal, we say, correctly found as they did. His Honor, Mr. Justice Winston Anderson, one of your brothers, my lord, has actually spoken extrajudicially on this very subject, and we put that in our tab 3. He gave a speech at the Norman Manley Law School back in 2013, I believe it was, and he recognized in that speech the limitations of the Caribbean Court of Justice in relation to section 177.4. He recognized it as an impediment to the jurisdiction of this case, of this court's jurisdiction. And he expressed the wish that that situation could be improved. But he nevertheless recognized that any sound lawyer, and as any good judge must, and I quote him, there is little, if anything, that the CCJ can do, in effect, end of quote, can do, in effect, to change the Constitution of Guyana. As hard as it may be, my lord, and I say this with respect, for the judges of the apex court of an indigenous Caribbean jurisprudence to recognize it, you are constrained by your founding agreement, consent to by your sovereign member states, while this is a case that you may be constrained to agonize over legitimately. I say with the greatest of respect, it is an opportunity for your lordships when you give judgment in this matter and you decline the jurisdiction that I exhort you to do, you may yet find an opportunity in your judgment to make a remark, to echo the wish of Mr. Justice Anderson, to ask your member sovereign states to amend the agreement to give you the jurisdiction which you now do not have. May it please your lordships. Thank you very much.
Yes, thank you very much, Mr. Amo. We will take a short break at this point, and we'll come back at about 5 minutes to 3.
Well, may I just ask your lordship, I beg your pardon. I had prepared a speaking note. May I, with your leave, file it, my lord? I would be very anxious for your lordship and my learned friends to have the benefit of it. We can do it in the 5-minute break.
Yes, certainly.
Because it's already written up. Thank you very much, my lord.
That's fine.
Okay.
So again, I ask you not to come out of the court. That is, not to press the red square button, and simply to mute your microphones, and you may switch off your video.
Kite Radio.
Covering Guyana from coast to coast.
Demerara and Essequibo 99.1 FM.
Berbice 99.5 FM. Kite Radio.
आए यूं मुस्कुरा